and was satisfied that the shares were being sold at a value that was appropriate in the circumstances. Parliament also required that the requisite regulatory approvals should be obtained. All this, Your Ladyship, in compliance with Section 87A of the Public Finance Management Act. So that, my lords, there is no lawless race to completion. It is a sale grounded in law that is complying and ticking every box as required by statute. The petitioners, my lord, suggest in the titling of the petition that the matter involves the Public Procurement and Disposal Act. Nothing could be further from the truth. The Public Procurement Act, my lord, itself states categorically that it does not apply to the sale of shares.
Your Lordship, without much respect, it's my learned sin in not raising new issue that we did not touch in our application, especially
the face of the application.
Public procurement in respect to the extension of the orders. We never touched anything. It may prejudice in our response.
You never
Okay.
all that they say apply.
I'm on the Lordship.
Yes, continue.
So that, my lord, the point I am making is that the petition itself proceeds on a flawed legal premise. Lord, the general policy of the law, as we understand it, is that the courts should, so far as possible, respect the principle of separation of powers. The statutory architecture gives the responsibility for the sale of government-linked assets to Parliament to approve and to design a pathway. Unless it is shown that Parliament has acted illegally or in breach of the Constitution, the courts should be slow to interfere in that statutory architecture and to respect the principle of separation of powers. The question of economic policy and the application and use of public assets, my lord, is in the first instance a matter for the executive. Once again, unless it can be shown that the executive has acted illegally, the executive is subverting the economic circumstances of the people, or that the executive has not taken into account certain considerations, the courts should be slow to interfere. Lord, in the two affidavits sworn by the Cabinet Secretary, he has gone to extensive lengths to explain why it is necessary at this time or considered prudent to allow the disposition of 15% of the government's shareholding in Safaricom. Not to a foreign entity, my lord, to a Kenyan entity. Vodafone Kenya Limited. Well, Your Ladyship, the arguments put forward by the petitioners
Oh, apart from this. Okay, that is accepted. Continue.
yes, we get used to this from time to time.
Okay.
The arguments put forward by the petitioners to the effect that somehow it will affect their subscription or somehow it will prejudice Mama Boga suggests that Safaricom is being liquidated. This is about a sale of shares, not about the liquidation or winding up of a company. The company will continue in existence, will continue to offer world-class M-Pesa services, will continue to serve Mama Boga, and will continue with its mission, if called upon, to offer a technology platform for the elections. That will not change, and there is nothing on the record to suggest that the entry of a new party will somehow change the trajectory of what we'll all accept is a Kenyan icon. The argument about sovereignty are weak at the very least. So Safaricom's shareholding structure already includes foreign ownership. I am struggling to understand how the sale to another Kenyan company will somehow threaten national security, affect our sovereignty, and lead to a breach of our borders. Well, this is purely speculative. What we have before this court involves the sale of shares. This is the subject matter of this petition. These shares are listed securities. They are traded on the Nairobi Stock Exchange. They are not somehow going to be spirited off to the Isle of Man or to some far-flung place out of the reach of the court. In the fullness of time, and having had the petition, the court finds some illegality or some other reason to vitiate the sale, Article 23, my lord, your ladyships, gives the court wide remedial power. The court can fashion such remedies and reliefs as it considers appropriate in the circumstances. There's been a suggestion that somehow the sale of these shares will dissipate our intergenerational wealth. And I've struggled with an answer to this proposition. The Cabinet Secretary has deposed and deposed to the fact that Safaricom delivers a dividend of 7 billion shillings annually to the government. The sale, my lord, will result in approximately 204 billion shillings into the government coffers. If Safaricom continues to deliver a dividend of 7 billion shillings annually, the Cabinet Secretary has told us, and mathematics will tell us, it will take 30 years to realize the gain from this sale. Furthermore, the government will receive 40 billion shillings upfront as dividend I will continue to retain a 20% ownership in the company. To what are these funds to be applied? The funds are to be applied towards various infrastructure requirements, indeed, the expected inflows have already been factored into the current fiscal framework.
The judge is still there?
I beg your pardon, she seems to have...
She's there. Yeah?
She's there, Your Lordship. Just the video is on.
Oh, okay.
It has been going on and off from time to time.
So, Judge, can you confirm that you are still with us? Judge Aburini? Can you confirm that you are still with us?
Yes.
Okay.
Yes, Honorable Presiding Judge.
Thank you. Let's continue.
Thank you very much, my Lord. Thank you, Your Ladyship.
Yes.
So that, my Lord, the amount in question, I was saying, has already been factored into the current fiscal framework. Which the National Treasury projects to use in implementing macroeconomic and fiscal policies, as well as managing the national public debt.
On a point of order,
Yes.
Your Lordship,
Yes.
I really hate to interrupt my learned friend, Senior Counsel John Ohanga. But are you satisfied that he's not really now arguing the petition? He came before this court really
So
to find.
I was going to raise that question, whether now
Yeah.
there will be need to only the application, because what you have with John is really
Yeah.
something.
Yes, my Lord, because we have to bend over
The
backwards.
formal application.
My Lord,
Here we are talking about the extension of the legal.
yes, it is critical. It is critical because Senior Counsel suggested to you that the public interest swung in favor of maintaining the status quo. I am demonstrating, my Lord,
Yes.
that the public interest, that issuing an order of status quo is inimical to the public interest.
Well, you should have started there.
Yes.
So that these others come as an example.
Very well.
That's
Most
the
of
way
them.
you are proceeding.
Thank you very much, my Lord.
You have in the application.
I'm guided. So, the point I'm making
Yes.
is that the order, any orders of status quo
Yes.
would be inimical to the public interest. Although the petitioner's public interest case is largely abstract. There has been mention of Mama Boga, there has been mention of M-Pesa, there has been mention of elections. But there has been nothing stated to displace this significant public interest in the application of these funds towards some of the infrastructure projects that are set out in the Cabinet Secretary's replying affidavits. Those, or that infrastructure, roads, airports, bridges, dams, those, my lord, constitute intergenerational assets. It cannot be said that one class of shares, if sold, will dissipate our intergenerational assets. We must think about this broadly and in a way which advances the needs of future generations.
Are you about to finish?
Yes, I'm about to finish. So that, my lords, the status quo, if maintained, would have to be very closely defined, because Parliament, the National Assembly, as I said, has given its approval. The approval is lawful under Section 87A, and it has set out a runway. And that, my lord, is the status quo. The status quo cannot be defined as equating a conservatory order, because it then becomes final in effect. And would have the effect, my lord, of substantially determining the dispute, because there's a real threat that the proposed purchaser could walk away. The guidance given by the Court of Appeal, I beg your pardon, my lord, your ladyship, the Supreme Court in Munya requires that the public interest be taken into account, constitutional values, and proportionality. And such orders are not to be issued lightly. In our respectful submission, it is this court's responsibility to accept the approval by Parliament and to allow the progression of the transaction. Because there has been no demonstration that there is anything unlawful about this transaction. There are certain points my learned friend Mr. Musangi will be making, and I will cede the floor to him. I must have for your time and for the patience.
And Musangi, you want what I told you.
Absolutely.
The application of the Italy model.
Right, yes.
Don't argue the application.
And that is exactly what I intend to do. My Lord, I also intend to steer clear of areas that have already been covered.
Yes.
And I think obviously I was mentioned in passing, I'll canvass that, but that's not what is before you.
Yes, yes.
I am the chairman of the Central Bank of Kenya. More specifically, my Lord, I am the non-executive chairman of the board of the Central Bank. Perhaps before the petitioners decide whether they want to formalize their statements into an application, they might want to consider the actual role that I play. My Lords, Your Lady, the principles for conservatory orders have been canvassed extensively into simply three. Public interest considerations, consideration of constitutional values, and last but not least, proportionality of impact. All of those are in Gatirao Pitamunya, and they are well known to the courts. My Lords, let me focus on the last one. The first two have been extensively canvassed by my learned senior colleague. But in so doing, let me state that I have the benefit of a perspective of the fiscal impact of conservatory orders, given where I sit at the Central Bank. My Lord, let me put stark numbers on the table for the court to understand. My Lord, a transaction of 244 billion shillings is on the table. And my colleagues may sit and argue, as they have done, that there is a danger of dissipation of the subject matter. And in the same breath, they argue that there is no loss from conservatory orders being issued. The following is the loss. My Lords, put 244 billion shillings conservatively in a money market investment at 10%. Every year, those funds would yield 24.4 billion.
So you saying the treasury is going to invest?
No, but the point I'm making is the following. Let me complete my point, my Lord.
It is very, I would really hate to interrupt my learned senior and senior counsel. But is that information in an affidavit? And secondly, he admits that he is part and parcel of this particular transaction, and therefore he should be an expert witness and not representing the regulator.
If I may finish. Yes. Yes. My Lord, the point I was trying to make, as my learned friend pointed out to you. Yes. Correct. Correct. Now, absolutely. And my Lord, what I want to bring to the fore for the court to keep in mind is the National Infrastructure Fund will be implemented progressively, naturally. So the funds will not be kept in a current account. That impact translates to 72 million shillings every day. And what is the converse? The converse is,
My Lord,
as
again,
long as...
my Lord, again, I'm very sorry for this. Is that in an affidavit so that we can advert our minds on it?
The matters the court can take judicial notice of. We can
Those are very technical matters as for counsels and the court to take judicial notice. Mr. Musangi, the chairperson of Central Bank, has information which the court does not have. And he should put that in an affidavit so that we can cross-examine him.
Yes,
We do not have...
Take your seat.
Yes, thank you, Lord.
So do not, what is saying
My Lord, yes.
So do not use it.
I'm not using personal information. I'm not using central bank information.
Yes.
I'm only...
And I'm questioning you again.
Yes.
Tell us parts or arguments in the context.
Absolutely. My Lord,
Nothing outside.
nothing outside.
Yes.
And my Lord,
That I will stop.
yes,
And
absolutely.
Your Honor, we cannot allow false analogy in court. That's a false analogy. It's scientific.
Sit down. I'm going to the issue. Move on. Sit down. Let me read. I'm told him I was talking this. Yes.
My Lord,
In that context.
yes, may I just be clear that I'm not talking about central bank. Anybody with money in Kenya knows what a fixed deposit is. Anybody with money. It's not central bank. Let me move on, my Lord, since they fear the impact from the side of the treasury. Let me talk about...
Through an affidavit without knocking.
Absolutely.
But as
And my Lord,
at now,
yes,
you speak yourself in the scope.
correct.
Yes.
My Lord, let's look at it the other way. As long as there is a status quo in order, the shares cannot be paid for. That is a fact. And if you extend a conservatory an order today, or create one because it has expired, if you issue one, those shares cannot be paid for. My Lord, if we hypothetically finish this case in July, and you issue a ruling telling the petitioners your case had no merit, the people of Kenya will receive the same 244 billion shillings, not a penny more. In which case, what would have happened is you would have granted a conservatory order to a party that has not proven its case. And the impact of that order will not be remediable by any person sitting in this courtroom. Not one. And at the same time, my Lord, and this is in the affidavit, the impact on our capital markets in terms of confidence will have been absolutely destructive. What's the remedy for that? My learned friends were at pains to tell you about 40 million subscribers in Safaricom. My Lord, government, the National Treasury, and Parliament represent all of us. Not just 40 million, all of us. And the people of Kenya have had their say through the parliamentary process, through the public participation underpinned in that process, in compliance with the law. And ultimately, on 12th March, the sessional paper from the Parliamentary Select Committee was placed before the House with a motion for its approval, after all these processes have been complied with. So we have constitutional compliance, statutory compliance, and procedural compliance. You have not been told one single breach of any of those processes to encourage you or convince you to issue a conservatory order. In fact, in the main petition, the only pleading of a breach was that Parliament is not being involved in this process. And the facts belie that assertion, including the application by the petitioners for recertification, which then attached the motion under sessional paper number 3. So, my lords, if you consider the fact that the doctrine of separation of powers, the principles of public participation have brought in 60 million Kenyans into this process by their representatives or by the people who made direct submissions, what then are we stopping? And my lord, when you consider this court's broad remedial powers in closing. Our courts have nullified presidential petitions. They have impugned many other processes, but they only do so when the party has proven the illegality, not before. So what is before you from the petitioners is tantamount to a preemptive strike, cause the damage and let the consequences lie where they may. My lords, my plea to this court is not to entertain a preemptive strike. Call everybody here. Let's hear them. And let's hear them soon, so they can actually tell you the facts. And it is clear from what I heard earlier from the petitioners that their house is not yet in order. They didn't know who they were suing. They didn't know what they wanted to claim. They now want to amend the petition. We don't know what the amendments are, and come before you with a cleaned up, polished case. If they are not ready with their own case, how can they in the same breath ask this court for conservatory orders? And finally, my lords, even as you consider, and I know it will come before you, the parties who want to be joined, I will state that before we are served with the application by the first party who applied, although we've seen it on the court portal, and the second party, Mr. Kenyan's client, they ought to show a distinct interest in the matter. And I say this because, my lord, you have been told there are 40 million M-Pesa subscribers. If the qualification to join this suit is simply having this phone and an M-Pesa line to say I have an interest because I send M-Pesa once in a while, then, my lord, we could very easily have another application when we arrive at the hearing date from another subscriber, maybe 10, maybe 100, maybe 100,000. Are we going to let everybody in because they have an M-Pesa line? This case will never end. It will never end. So, my lords, on that basis, I urge you not to issue any form of conservatory orders because nobody has laid any basis whatsoever for impugning this process in advance. Let's hear the case of most of that.
Is there anybody else who wishes to add?
Yes, my lord, very briefly.
Yeah, very briefly. I give you only 3 minutes.
Very well, my lord.
Yes.
My lord, Uganda. For the third respondent. My lord, besides aligning myself with what Milan is immediately, I want to add the following. My lord, you've been addressed on sovereignty of the nation. And my lord, I invite you to consider the provision of Article 1.2, which specifically states the people may exercise their sovereign power either directly or through their democratically elected representatives. My lord, that's Article 1.2. My lord, Article 94. Role of Parliament. The legislative authority of the Article 94.1, my lord. The legislative authority of the Republic is derived from the people and, at the national level, is vested in and exercised by Parliament. My lord, sovereignty. Number 2, my lord, Parliament manifests the diversity of the nation, represents the will of the people, and exercises their sovereignty. My lord, the will of the people is not in an affidavit filed by 2 persons. It's an affidavit and an endorsement by the representatives of the people who are Parliament. My lord, number 3, Article 95, the National Assembly represents the people of the constituencies and special interests in the National Assembly Article 95.2, the National Assembly deliberates on and resolves issues of concern to the people. My Lord, one such issue is the sale of the shares before you. My Lord, the issue of the sovereignty is settled from those two parts. Article 1, Article 94, and Article 95. My Lord, you have not been demonstrated to one illegal action performed by the people that the will has been vested to sort that. Not one, my Lord. My Lord, so that the status quo is to maintain the status of the will of the people as manifested and expressed by the people, not by two individuals. Not by two individuals. My Lord, number one. Number two, my Lord, status quo vis-a-vis the prayer sought. My Lord, I invite you to consider the final prayers of the petitioners, and amongst the very key mandatory prayers they sought, an order directing, a declaration that the sale or alienation of the government of Kenya shares in Safaricom cannot be initiated or concluded without prior approval of Parliament and conclusive public participation in accordance with the law. My Lord, that has been done. That is being done. My Lord, so that you are being asked in one way, we'll come before court, let Parliament do the job, but on the same breath they're telling you, stop Parliament from doing its work. And my Lord, it's curious to know that Parliament is not a party to this suit. That's very intentional and calculated.
They're asking us to stop Parliament.
No, my Lord, that's the prayer. That's the prayer in the petition. That's the prayer in the petition. That's the status quo, my Lord.
It's the only prayer.
Amongst the prayers, my Lord. Yes. Yes, so that, my Lord, they're asking you to stop what should be done. Separation of powers has been alluded to in Milimani. I will not be labor. My Lord, in exercising that parliamentary role, my Lord, I'll invite you to consider the affidavit of the CS, my Lord, and specifically paragraph 4. And my Lord, what the petitioner sought, my Lord, was addressed by this court, Justice Mugambi, on 23rd of March, and he specifically addressed worries and concerns. And my Lord, this Cabinet Secretary, at paragraph 4 of the supplementary affidavit, confirms that every worry that anyone may have thought has been addressed. My Lord, in summary, number one was effective date. There shall be mandatory regulatory approval, which is ongoing. GOK shall retain 40.2 billion. Funds to be paid. That to safeguard loss of public against loss of jobs for existing staff, there shall be no acquisition-related redundancies in Safaricom PLC. My Lord, that's amongst the present of such. So every concern that you would have been told to worry at the future, at the end of the finality of the petition, has not been canvassed and addressed. All the worries that you're addressing in the petition have been addressed. So what is the necessity for a status quo order? My Lord, the answer is absolutely no. Absolutely no. There's not a single illegality, there's not a single infraction by any institution required to perform its role in the approvals that has been cited to you. So that, my Lord, the culmination of this is that there is no basis for you to find that there is any order to even consider granting to interfere with the status quo of the sale of the shares. I pray that you consider and do not, because there are no orders, and my Lord, it's important to read the orders of Justice Mugambi, that you consider and find that there is nothing to issue because the orders are already lapsed. Do not issue any fresh status quo orders. Thank you.
My Lord, I will be addressing you briefly, not on the issue of conservatory orders, but the other oral applications that were made. I act for the 7 respondents, that is Vodacom Group.
Yes.
My Lord, Vodacom Group,
Your miss?
Abdallah.
Very briefly.
My Lord, Vodacom Group,
Vodafone has made an application, isn't it?
we have made an application to be struck off.
Yes.
I'm commenting on the oral applications before you. There were 2 oral applications. One was to add Vodafone Kenya Limited,
That's Kenya Limited.
and one was to amend the petition.
Yes,
So I'm addressing you on those.
those two.
On those 2 issues. And I'm reminding you to issue directions on our strikeout because that was a requirement.
I think that's okay.
Because
now.
it was not mentioned by the
So,
petition.
issue the elections. On our petition. Dated.
The application is dated February. I'll get the exact date for you, of course. What is the date? I'll get you the exact date, my lord. The application for strikeout.
Let's indicate our applications to put that.
11th of February,
That's what I was.
2026. 11. Yes, my lord. My lord, just to remind you, that application is currently unopposed.
Lord, before
But
I hate to interfere, but that particular...
But Mr. Lempa has been interfering consistently.
My lord, I want to correct a position. It is responded
And I
to.
think it's extremely discourteous of Mr. Lempa to make a point of rising and interrupting every single council of the respondent.
All of you first. We want order because we are a sort of order. So every time a council is on his feet, if you want to object, right, stand briefly, okay, say you want to object, and then you sit down, then the other council should take his or her seat, so that it doesn't look as if it is a confrontation. That is an established rule in our practice. All of us are police. We know that is all what happens, right?
Yes, my lord, thank you very much for
So-
that guidance. We have responded.
Just state what you are saying. Then
We have responded to that
particular.
particular. We have responded to that particular application on the grounds of position and submissions dated the same date, 14th day of April 2026. It is in the portal CTS court tracking system, and it was served on her known email address. So the reason why I rose, and I'm very sorry, is to prevent her from further misleading the room. Thank you, my lord.
Father is leaving the court. Maybe she doesn't have the documents.
She has them because
So we raise issues in good faith, eh?
Yes.
Without insinuating any bad faith on any.
well guided.
Please.
That particular.
That's good information.
Yes.
Yes, it has it now. Can speak.
Yes, thank you. So my point is that the strikeout application is
So
very...
let me erase it as an opposed, because if there is even a grounds of opposition, that's an opposition to your application. So do I erase that point?
You can note that they have filed grounds of opposition and submissions.
Yeah. So let's erase that.
So my lord, the point I was making is that the strikeout application is intrinsically linked to the oral application to add Vodafone Kenya Limited as an 8th respondent. My lord, the first correction to make is that Vodafone Kenya Limited cannot be added as an 8th respondent because we currently have 10 respondents to these petitions. So the 8th respondent currently is the Capital Markets Authority. The 9th respondent is the Privatization Commission. And the 10th respondent is Vodafone Group PLC. So So perhaps, and I don't impute bad faith, I think Mr. Lempa simply just needs to remind himself when the 3 petitions were consolidated, we had a revised order of respondents, and we actually have more respondents, so we don't have to fight over everything or impute bad faith to colleagues, Mr. Lempa.
Vodafone is already a party in one of the petitions.
Vodafone PLC.
Kenya.
No, no, my lord.
Yes.
These are separate legal entities.
Yes.
Vodafone Kenya Limited.
Yes.
The oral application to add it
Yes.
as an 8th respondent,
Correct.
it's never been a party to any of the 3 petitions before you.
Yes.
The strikeout application that we made
Yes.
was on the basis that our client Vodacom Group, based in South Africa, is not a contracting party. The actual purchaser of shares, my lord,
Yes.
is Vodafone Kenya Limited. So if you are allowing an oral application to add the correct purchaser,
We have not allowed it.
I am just saying that they must be
Yes.
looked at together. Because actually the oral application to add the correct purchaser
Yes.
is inherently accepting
Yes.
that our strikeout application is indeed well-founded.
So you are supporting the application to buy Vodafone and remove your client.
They are saying,
Yes.
give us direction so that they are argued together, not today orally,
I get
without an affidavit in support. Let
Now-
them put in their evidence, give us direction, then we come back to you, and everyone else can participate. So the first thing is we cannot deal with this orally.
Yes.
The second,
Or
or
what you have said.
yes. So the second is to note that we already have 10 respondents to these petitions, my lord, so that we are careful when we are adding or removing to have the correct citation. So it's just something I point out so that we don't get ourselves further confused. Then the second oral application before you is to grant leave to amend the petition. We were told by senior counsel to correct a few issues. We do not have a formal application before this court that allows the parties to respond to it and to take instructions as to what are those issues and whether or not they should have been canvassed earlier, given that this petition, this specific one, E051, was filed in January, and we're now in April. But it is only to point out from the submissions made by the Petitioners' Council that these few issues do not appear either minor or non-material, and therefore they are deserving of a proper formal application and court scrutiny. And the reason I say this is because if the amendment of a petition is to add a party that is currently not before you, that is a material and substantive issue, number one. Number two, if it is to add, for example, as we have had, an issue to do with the IEBC and the election regulations, again, those cannot be classed as a few issues, because that is probably going to significantly change the nature of the issues before you today. So as we stand today, we came ready to meet the petitions that are before this court. There are 3 petitions, and we would urge the court not to disadvantage the respondent by allowing us to be ambushed by oral applications. And then there's a final point, my lord, I have to make, because I think I've been accused of bad faith, and my colleagues.
We sorted out that issue.
No, my lord, I have to
Don't worry.
I will have to respond. Because senior counsel said, and he repeated, that eventually when this matter is canvassed on the merits, there would be other and deeper arguments, including the sale of shares to a foreign entity. And then he emphasized it by saying, and I repeat, a foreign entity. But my lord, that is a gross misrepresentation of facts, because the purchaser of the shares is Vodafone Kenya Limited. It is an existing shareholder, and it is a company incorporated in Kenya. And they will show you this because they want to file a CR12, my lord. in support of the application. So their CR12 will confirm what I'm saying to you. It is a Kenya company. So when senior counsel misrepresents and say this is a sale of shares to a foreign entity, and you have reminded us we are a court of order and a court of law, I must object strongly to this mischaracterization. I think it is meant to make you scared as Kenyans that you are losing something. I think I need to remind you that Vodafone Kenya Limited has been in your journey along the way and is not new to Safaricom and is within very much the jurisdiction of the Kenya courts and is subject to all Kenya laws. So we would ask you for our directions. Thank you.
Anybody else?
Yes, good afternoon once again, my lord. My lord. That's fine, my lord. Your Lordship, I represent Vodafone Group PLC.
That is Mr.
Ismail, you can record your Lordship. ESMAIL. Your Lordship, I think it's important for housekeeping purposes to point out, as Mrs. Abdallah has adverted, that when the petitions were consolidated by your brother Justice Mugambi, Your Lordship, there were two petitioners whom Mr. Lempa represents, and then there were two other petitions filed by unrepresented parties. And we took the liberty to consolidate all of them and put the respondents down. And my client, Vodafone Group PLC, is the 10th respondent in the consolidated petitions, Your Lordship. I will make 2 points, none of which touch on the arguments that have been made before Your Lordship and my ladies. And those 2 arguments are as follows, my Lord. Firstly, the petitioner...
Where is my neighbor? Is the fellow with
Yeah, Your Lordship, I think it is important to point out that the petitioner who cited my client as a respondent is actually not interested in his petition at all. He is not present in court today, Your Lordship and my ladies. And for that purpose, Your Lordship and my ladies, they have not even responded to the submissions filed in support of our preliminary objection, which is dated the 4th day of February 2026. And I believe Your Lordship and my ladies have had an opportunity to look at the substance of that PO. It is simply seeking to strike out my client from these proceedings. Your Lordship and my ladies, I think my client's position is that we are not parties to the transaction and are not affected in any manner by the dispute between the parties. So, Your Lordship, to continue to occasion costs on my client to sit through these proceedings, whilst the petitioner first is not interested, and secondly, service was not effected as per the CPR, as well as the fact that there is no nexus between the allegations in the petition and my client, Your Lordship and my ladies, are the principal reasons on which we ground our application to be struck out. So, Lordship, cognizant of the fact that the current contestation is on the issue of potentially conservatory orders, as well as the other issues that have been brought before the court, we would be urging Your Lordship and my ladies to give us directions in respect of our PO at the appropriate time, my Lord. Thank you, my Lord.
Just one issue. Paragraph 45 of the ruling.
That is
Mr. Maro.
Yes. 1 minute, please.
Yes, at paragraph 45 of the ruling.
Paragraph 45
of the ruling dated 23rd March 2026. The court was addressed its mind that this court may have to consider other aspects of preliminary objections that might not have considered. So we also will be seeking directions on the PO that we filed. I filed the AG filed a preliminary objection dated 17th March 2026. So we will also be seeking directions on that. Thank you, Judge.
Yes. The concept is given for us. However, I heard Mr. Haga objecting to this joint. Yes. And they say that they would object. Now, I need to bring to their attention Rule 7 of the Junior Rules gives you the leeway to enjoin us suo motu. I think they need to look at that rule once more. With respect, the owners and the drivers of the petition.
Suo motu under Rule
7. Rule 7. Of the Junior Rules. You got notice 117 2003. Yes. Number one. The joinder, I suppose, was made, the door was open. Good morning, Honorable His Excellency. I want to say you don't object to our application. And therefore, the issue of the opposition, in my humble view, does not arise therefore. The owners of the petition have said, come on board. And therefore, now looking at the discretion you have, totally unfair. Totally unfair. Not even conditional. And Mr. Ohaga said, the Supreme Court has said, an interested party should be enjoined because they made use of that. Rules made pursuant to the Constitution. Legal Notice 117 of 2003 states, Rule 7, you have unfettered discretion. Having said that, it is my client's interest, therefore, to have the subject matter alive for adjudication with the status quo order in place.
I think we joined.
Yes, but I'm saying.
Don't argue anything substantive.
Yeah, but I'm not arguing substantive.
Yes.
I just want to bring a point of law. Because of now, if my client comes on board after the horse has bolted, these two will be exercised.
Consider these applications before we hear the petition.
Yes, but I'm saying.
And I was going to come to those particular applications.
Yes.
So we were listening arguments in respect of status quo.
Yes.
And then we go back now to the specific applications and give directions.
Yes, I wholly agree. But I'm saying my client then, because we filed an application first, before we came in, and that application had been served for notification to everybody. And I received communication from Mr. Lenny that he was not objecting, he would in fact consent to the joinder, which he did.
Yeah, the petitioners are not objecting.
Yes.
We have no problem with that.
Yes.
Except now, Dr. Alda,
Yes.
I'll give directions in respect of that.
Yes, but I need to close by saying,
Yes.
Your Lordship,
Yes.
if you let the horse bolt, in other words, you don't extend the status quo.
I warned you, Harrison.
Yes.
Don't argue anything substantive.
But that's not substantive, my
I'll
lord.
give you
I'm saying, no, hold it. Now that interrupted you.
Harrison, I'm the one who is telling you.
Yes, but they are there raising their voices. Of course, they have to hang on. They need to have the sound bites. They need to have the sound bites. They need to see the resistance. That's why they're with respect.
God bless you and propose you. Anyway, you're getting your point, Harrison.
Let me close by saying.
Yes.
I heard his excellency saying there's a limited window, and they have sought 7 days, so that everybody can come and do. I don't see the prejudice. Thank you.
All right. I think now let's come back to the petitioners.
Yes.
And then you.
Your Lordship, thank you for your great patience. That goes to show that this is a matter, as I started by saying, of grave national importance. And I'd like to note 14 million subscribers to M-Pesa. We didn't lay a claim that we're here to represent them, but they're all interested. You see, there's a famous doctrine in law, res ipso locuta. Facts speak for themselves. It's a matter of grave national interest to all the Kenyans. My Lord, it has been argued by my learned friends that the court should respect the doctrine of separation of powers. Yes, there is no problem with that. But Parliament, in its wisdom, or lack of it, went against a court decision, which was issued by your learned brother on the 23rd of March. They went ahead on the 31st, you had it so eloquently placed before you. So that is a kind of respect for separation of powers that our Parliament has. Your Lordships, it's the same Parliament. I've been a member of Parliament for quite a while. Yes, and Articles 1 and 2, that the sovereign power, the separation of the people, rests in the people, which can be exercised either directly or indirectly through their elected representatives. And where the elected representatives falter, as they did with the finance bill in 2024, then the citizens have a right to exercise it directly. Your Lordships, that's what the Gen Zs did. It is the same Parliament, Your Lordships, that went against a direct court ruling. Just an example, that our policemen were not to be deployed to Haiti. We thank God they've all come back -3 or 4. Against an express order of the court, this Parliament and the executive.
May I respectfully point out that
Just
the
an
reply is
example,
limited
John.
to matters of law.
This is a matter of law, my Lord. It's really a matter of law.
It's not a matter
This is decisions of the courts, my Lord, that have been.
He's trying to demonstrate.
I think you're
Kind
to
of
respect that.
respect that should be
I'll
there.
be very brief for your
In the
comfort.
separation of powers. So I'll allow you to give that one example only.
Yes.
Don't give it there.
Okay.
Exercise politics.
And let me then.
After that, let him revert back to being a lawyer.
Oh my, that is what I am, my Lord. I'm here in that capacity. Because we're just trying to highlight how the executive and Parliament have failed to respect court decisions. And they do so with impunity, including the security laws, which were ruled unconstitutional. So, my Lord and my ladies, the orders by Justice Mugambi are very clear. It is ordered under paragraph 2 that the balance of justice in favor of granting immediately an order that the status quo to be maintained until the bench, which is this bench, is in place. I think we are in agreement that the onus is on your Lordships to extend these orders, and that is our plea very strongly. My learned sister Abdallah is scared that I was going to produce a CR 12 to prove the point, my Lord and my ladies, that Vodacom, South Africa, Vodafone, Netherlands, own 350 shares out of a total of 400 shares in Safaricom. in is it Safaricom, Kenyan Limited?
Vodafone.
Yeah, Vodafone, Kenya Limited. Vodacom, Kenya Limited. 50 shares by the Netherlands Vodafone Group and 350 shares by Vodafone. Vodacom South Africa. Therefore, Vodacom Kenya Limited, your lordships, is a completely foreign-owned company. That is the truth of the matter. That is truly the matter. To allay the fears of the chairman of CBK, I wish these very reputable international organizations will stand guided by the fact that there is a contestation about the share of these shares. I personally, on behalf of the Kenyan people, because they can get a better deal, that's for sure. In business, you don't get what you negotiate, you don't get what you deserve, you get what you negotiate. It's a negotiation issue.
Matters of law, matters of law.
So to say, no, I'm just responding to what your able chairman of CPK said.
Yes.
That was an issue which was raised.
It was raised by,
Yes, from the bar.
yeah, from the bar. And I have the right to respond. Because, my lord, it was expressly raised. So it must be contradicted. Because all this in an effort to make believe there is not an issue of an urgent national importance before your lordships. This is why we seek these conservatory orders. Well, given the very fact of National Infrastructure Fund, maybe for information of CPK Chair, CS Badi is before the IMF board, just for information. And these are the issues that they are confronted with. And some of this infrastructure fund itself is subject to litigation. So my lord and my ladies, nothing, we have shown, we have proved that Parliament acted in bad faith, which is one reason why, because they went against the ruling of Justice Mugambi. My friend Muganda wanted to show one thing that goes to show this need to issue conservatory orders. Because if we don't, your lordships, we will come here and be engaged in some academic exercise when everything will have happened. We are all Kenyans. We love our country. And believe you me, we will prove, and I don't want to argue that point, because it is in our main petition, the undervaluation of the Safaricom shares. We will not allow this, your lordships, just to go unnoticed. Therefore, I strongly urge that when you retire, to consider your ruling, you'll act in a manner, as we all know you well, justly, and taking into account the public interest, the immense public interest. Even taking 40 billion up front, you want to forego your own profits? What are you telling the country? My friends may want to add one or two things.
Yes, my lord, thank you very much. I have sat down here seeing my learned senior, Mr. John Ohaga, tell you that orders of Justice Mhochi were ousted or were stayed by the Korowati. That is not true. The truth of the fact is that application E14 of 2026 was heard before Justice John Mativo, Justice Gashoka, and Murungi. And they said that they cannot stay declaratory orders or orders of certiorari, as has been held in so many decisions of the Korowati. So all the submissions, all the interactions made by Mr. John Ohaga should be expunged because he's representing an Attorney General contrary to orders of Justice Mohochi, which were not ousted.
What is the case number?
The case number is E014 of 2026. It's the application that was before the Court of Appeal. And if you look at the conclusion of that particular ruling by the 3 judges, it is clear that they declined to stay the order, declaratory orders because they are negative in nature. That is very clear.
When was that?
It was done on the 10th day of March 2026. My Lord, on joinder, we have been told that Irongo Nyakera and the governor, former governor of Nairobi, have no interest. My Lord, you cannot trash Article 22 on local standard. And secondly, Irongo Nyakera, for example, is the one who negotiated the IPO in 2007. And therefore, this is someone with a lot of, actually, Mr. Andrew Mukita Musangi comes second to the information that he has about Safaricom, to Mr. Nyakera, to the intended interested party. So therefore, my Lord, these are not idlers. They are not mischief makers. They are people with substantive information that can assist this court arrive at a just and conclusive determination. The Lord, my learned colleague, whom we learn a lot from, Senior KALONZO Musyoka, Ambassador, has told you that Parliament violated the doctrine of separation of powers. My Lord, if you look at Standing Order number 89, it bars Parliament from proceeding on matters that are pending in court, so that it is sub judice. And the Attorney General is well represented in this matter and ought to have informed the speakers of the National Assembly. Information which we believe that the speakers would have ignored, that this matter is pending in court. Standing Order number, and I think Article 103 of the Constitution of Kenya is very clear that standing orders, my Lord, are part of this Constitution. I think 103. Someone check for me.
Standing order number 89.
Standing Order 89 of the National Assembly, not of the Senate. Standing order.
It's actually standing order number 89 3C.
Yes.
It's what I was about to address you on, but you told me to hold my process.
My Lord, yes, my Lord, Harrison Kenyan ought to have been my pupil master. But for some reasons, I never went to his chambers. Thank you very much, Senior. That is the standing order. It's very clear that the committee of the 3 arms of the government does not allow Mr. Masika Wetangula or Amason Jaffa King, the Speaker of the Senate and the National Assembly respectively, to admit matters that are pending before this court. And I'm reminded by my learned senior, your team, that both are lawyers, actually senior counsels, I'm told, and therefore they ought to have known that this matter is pending before Parliament, before this court, and it would be prejudicial for them to continue to deliberate on them. But my Lord,
your permission. My good friend and brother, who I believe should be in Parliament because he has a lot of passion, knew the significance of this matter. For some reason, there was a deliberate omission of both the National Assembly and the Senate in being joined to these proceedings. So they are accusing a party that is not present before this court for response.
On that point, I think you have said enough.
yes, my Lord, I have said enough.
Also buttressed by
Yes, before I was actually put
Now,
down.
you go to the next point.
The next point is on the affidavit of Mr. John Bandingongo, the CS, Treasury, which my learned colleagues glowingly talk about. My Lord, if you look at that particular affidavit, it fails to annex the Hansard of that particular day, because even members like John Karoli Omondi, the MP4, opposed and actually brought to the attention of the Speaker that whatever they were doing is not in the best interest of Kenya. My Lord, then P for Suba.
Yeah, and he's a lawyer.
And he's also a lawyer, my Lord, I'm told.
No, he is.
Yes, an advocate of the High Court of Kenya. My Lord, I wish to bring your attention to our further affidavit, dated the 15th day of April 2026, in reply to John Bandingomo's further affidavit. We have annexed that particular Hansard. We have also annexed a 15-page memorandum dated the 26th day of January 2026 by the Law Society of Kenya. Law Society of Kenya was advising Parliament under Section 4, I think, of the Law Society Act. And my Lord, they are very clear, and my learned colleague alluded to this, my learned senior, that even though they recognize the importance of having a free debt country, you do not sell the goose that lays golden eggs. That's the conclusion of the 15-page, the conclusion of that particular memorandum, 15-page, that is annexed to the affidavit of Mr. Ashoka, Tony, and his learned petitioner, his good petitioner, Professor Ogola. So therefore, it is not idle when we say that Parliament, National Assembly, is not acting in the best interest of, and that is well canvassed in that particular replying affidavit, which was filed yesterday, and annexures were done. What Mr. Marwa's client, and because I don't want to call him John of God.
I don't want you to go into details because you are exercising your right of reply.
Yes, I'm only trying, my Lord, with due respect, to debunk what that particular affidavit, which they have referred almost 10 times, by Mr. Ohaga, who is not even supposed to, because he does not represent, he is not supposed to represent the Attorney General, and Mr. Marwa. That particular affidavit has been responded to effectively by Mr. Ashoka, and you can see the mischief of Mr. John Badingongo of material non-disclosure. So therefore, my Lord, the conservatory orders that we have sought, we urge this court, if you are consider our submissions that are dated the 29th day of January 2029, that were also read by Justice Mugambi before he issued conservatory, or they don't want me to call them conservatory orders.
They are not.
Yeah.
Before status quo orders. And my Lord, I believe before this court rests to write its decision, we'll read the notes that were taken by Justice Mugambi, and all whatever they have said here was recorded, and those status quo orders were issued. And therefore, my ladies, my Lord, you have been told not to give a preemptive strike by the Central Bank chairman, board of directors. My Lord, what that amounts to is that you are being told, don't issue that, so that we go and score on the other side, so that you come here, 3 judges of probably about around 70 years of experience from the time they were admitted to the bar, to engage in an academic exercise. My Lord, tunaomba tafadhali. And I started by saying Safaricom PLC is as important to Kenyans as the Strait of Hormuz are important to the people of the Republic of Iran. Unless there is a question that you want me to clarify, I call upon Mr. Ndegwa to cross-pollinate on what I've said.
Your Lordship, I'll be very brief. I'll be very brief. Your Lordship, may I disabuse the notion may I disabuse the notion that we are not making an application for conservatory order. I refer you to the case Nairobi Civil Appeal 151, which is Invesco Insurance Company Limited.
So you know you have an application for conservatory order.
Yeah, I'm coming there. I'll show you how I'll link and annex this status quo to that order by this court. Yes, Your Honor. May I just read this judgment? Civil Appeal 151.
An authority,
Yes, I'm reading.
we have to have the right to comment. You have the opportunity
But
to refer to our authority.
Your Lordship.
This is never going to end, my Lord. As long as you keep that door open.
My Lord, we concede. We concede.
And I wanted to say, from the process power, and if we KB 408 explicates the status quo, has been used repeatedly. What is the status quo ante? What is the status quo post?
Yes.
That I would have said.
So that's
Yes, Your Lordship. Because he wrote to say that he also needs the opportunity. Correct.
Your Lordship.
You see, we don't want him to bring an authority which would make them ask for a right to hear. Otherwise, we are going to be here. How to get out.
Let me submit on it. The court will, if there will be need for them to reply, Your Lordship, then you disregard it. Permit just me to refer to it. Okay, I'm well readed.
My Lord, guided by Kenya, friend here, we concede. Okay, please, leave it to you.
All right. Your Lordship, I therefore submit that conservatory orders is a judicial remedy granted by a court by way of an undertaking that no action or any kind of preservation or that is intended to preserve the subject matter is actually an order of status quo for the preservation of the subject matter before the court until the motion is heard or the petition is dispensed with. On the separation of power, Your Lordship, I want to submit that that doctrine has since been penetrated by the enactment of Article 165 Clause 2D, Paragraph 2. That's no longer enjoying the constitutional virginity that it used to enjoy before. 165. Your Lordship. 165, Clause 2, Paragraph D, Roman 2. When we enacted the Constitution and gave this power the court to determine whether anything said to be done has been done in accordance with the Constitution, it gave you power to penetrate the acts and the actions and the functions of Parliament. It lost its constitutional virginity. Your Lordship, this doctrine is not as it was during the case of Madison. Granted the current enactment. On the question of the status of the status quo vis-a-vis our application for leave to amend, whether therefore we will have dissipated the subject matter will continue to exist as it is until leave is granted and subsequently an amended petition is filed. The grant of leave does not mutilate the current subject matter before you that we are seeking to preserve. It does not even erode it whatsoever. It does not even cease to exist. And that is what we are seeking to hold, so that Your Lordship, as and when time comes and that perhaps amendments are brought before you, you will have what to adjudicate over. Remember, the rules of amendments, Your Lordship, is not to completely dissipate the original subject matter, it's to add to it. Your Lordship, finally, the doctrine of proportionality will only be applicable where the petition before you is primarily for the enforcement of the Bill of Rights. This petition has been commenced pursuant to two fundamental pillars of the Constitution. Pillar number 1, Article 22 of the Constitution, and pillar number 2, Your Lordship, Article 258 of the Constitution. Article 258 of the Constitution invites you to see whether the Constitution has been violated. Article 22 invites you to evaluate whether a right has been denied, threatened, or been violated, or infringed. On those two fundamental pillars, Your Lordship, and most importantly, the question of the violation of the Constitution, Article 3 enjoins you to uphold, protect, and respect this Constitution. Number 2, Article 10 again calls you to make sure that in whatsoever we do, Your Lordship.
What point are you responding to?
Yes, Your Lordship.
What point are you responding to which emerged from their submission?
It was raised by my senior, Mr. Waga.
Which point?
Hold on, I'll answer the question.
Which point?
The point on proportionality.
On proportionality?
Yes, Your Lordship.
So this is about proportionality?
Yes, Your Lordship.
And finish up.
And the obligation,
Yes.
and the obligation bestowed upon this court,
Article 3 is about
the respect of the Constitution, the upholding of the Constitution.
duty of every person.
Yes. And you remember, Your Lordship, I submitted that this petition is premised on Article 258. If I was to harmonize those and read them purposively, Article 3 therefore calls you, while you are awaiting to see the alleged violation under Article 258, where the petitioners draws their blockers from, that you uphold the possession, that you preserve it. That's all the point I'm making, Your Lordship. Most obliged.
Your client.
Your Honor, I just request 2 minutes to clarify something that came from Mr. Msangi.
It's 254.
Just 2 minutes. Yes. Mr. Msangi spoke very authoritatively.
Yeah, you are.
A petitioner.
Represented by Mr.
I cannot see you well. That time you are standing there.
Yeah, I was technically displaced, but just give me 2 minutes.
I will not go that way.
2 minutes.
A lot has been said about your legal counsel.
Your Honor, you said I would just make it just 2 minutes. I repeat.
Well, the office is dissatisfied with the level of music. In which case,
I will obey, but I'll obey your order, Your Honor, but I'm begging for 2 minutes. I'll strictly take 2 minutes.
You see, I represented by legal counsel,
Especially senior counsel.
will be problematic.
Your Honor, I'm just begging for 2 minutes. Just 2 minutes.
And what are you going to respond to?
I'm going to respond.
To act in question.
I'm going to respond to what he said, that if you keep the status quo, they are going to suffer a certain amount. I just want to respond to that only.
No, that has been responded to by
Your Honor, I'm just requesting for 2 minutes. I will have been done.
You will pay the 15. What is the
You should have told the leper what you wanted to say.
Your Honor, just help me to 2 minutes only. I'm begging, just like any other person.
Everybody will pay for 2 minutes.
I'll only use 2 minutes. Then give me 1 minute, Your Honor.
Just end this.
1 minute, please.
Let me be firm on that. Please take your seat.
I'll obey, but I'm just waiting for 1 minute. Your Honor.
Please obey. If you obey, sit down. Go down. Please.
I'm going to obey, but I was waiting for 1 minute.
That is obedience.
Just obey and sit down. Now it's 2:20. Yes, let me consult with my judge here.
You denied me a chance. That's not fair.
So, Judge Ambureli, are you still there? Judge Ambureli? Oh, yes. So, it appears there are too many issues which are before us, and also a lot of assignments to be done, including giving directions in respect of the various applications pending before the court. We are aware that there are certain directions which were given initially regarding certain applications, especially the one dated 26 January 2026. Directions were given on that one, and also directions were given on the petition, replies and all submissions. So we wanted to suggest that if we can be able to find a pragmatic way of moving this petition forward, then that would be the best course to take. But if we have to go through the motions and spend a little bit of more time, for good reason, looking into each one of them specifically, then we are amenable to that. We have no problem. And we have noted that the arguments which have been put forward by the legal counsel, and I go back to what Senior Counsel KALONZO said, are substantive arguments to be made in the application of conservatory. So we have taken a view that we agree to come and hear that application for conservatory orders within 10 days. We take a date, which is appointed, those directions were given, the arguments, and then thereafter we give a substantive ruling on this. And we have also agreed as a bench of judges that as of now, up to the 10th day, we are going to extend the status quo order. And we have noted the submissions which have been made regarding the date when the status quo order was made, that was on the 3rd of March 2026, and other proceedings took place subsequently. We note that. So we would advise parties to desist from any form or attempt of disobedience of court orders, because that is the only way we can have a healthy democracy. Democracy where separation of powers is right and with dignity and the kind of respect, not what was being described in the So I would urge that. And we want to be fair to all parties. That's the reason why we are ready to sacrifice our time despite our busy schedule to accommodate parties. But towards the major goal of resolving the substantive issues. And then in the meantime, because I can see the application for joinder have been objected to, then once we hear the application for conservatory orders, we can also have a clear date to hear those other applications for joinder before now we hear the main petition. Because that is where the parties will matter if they succeed to be joined in the proceedings. So that will be those will be the directions of the court. Let me record specifically here, and I'll also talk to the judge here to see whether there is something else which we have missed. We record the language first.
Your Lordships, I take it that we, on behalf of petitioners, can go ahead and do the amendment.
Yeah.
You amend the petition as we have actually.
Yeah, I'll address that also.
Thank you.
So the amendment, before I recorded down what I just told you. The amendment, if it is in respect of bringing on board Vodafone, I heard you say that you don't have any objection, because that is the right one.
No, my lord, that what I said was you have to hear it together with strikeout.
We hear it together.
Because you are, otherwise you are advancing them ahead of our application.
All right. Then what we are going to agree is in the council, you say that within 7 days our applications to be filed.
Indeed.
So we shall ask you to file a formal application, 2 applications. In fact, one application for amendment and the joinder, isn't it?
Yes.
These two can go together.
Yeah, my lord, will be also filing a substantive application and submission on the participation of Triple OK and Mr. Andrew Mukita Musangi as the public officer will be filing those.
You're very welcome to file them.
We will give a general order.
We have rights to
We will give a general order that if you have any application to file, you file it and you serve it within 7 days because you are very serious. So that is a general order which gives room for all of you. Okay? So we will give that order. In the meantime, let me now record substantively what I have just told you.
Oh, can I just clarify, that does not change the 10 days within which the application will be?
No, it doesn't change it. That is quite separate. We shall put that one separate. When the others come, we deal with them as they come, depending on their nature. But where we can agree today, because directions on the hearing of the petition have already been given. We can even take a date for the hearing of the petition, and then we work backwards.
Yes.
So I think that's the best way.
Absolutely.
In the meantime, be thinking about a date around June. Around June for hearing of the petition.
For the petition itself?
Yes.
Yes, yes.
Then you work backwards. So
Yeah,
be thinking about a date. For now. So we thinking about a date in June for hearing of the petition. Then we work backward as we ensure that that date is kept as a matter of the petition.
Because right now I'm most interested in the application for conservatory.
No problem. 10 days. That has already been
Within 10 days.
We are not changing it. Do you want us to extend it?
No. 10 days. 10 days, my lord.
10 days is reasonable. That's what we consulted.
Yes, my lord.
We don't fix 14, but we said 14 is too much.
The conservatory orders, the other applications don't affect it.
No.
They can come after.
That is separate.
No.
We are putting it separate.
Well, Lord, for clarification, I would like the applications for the participation of Triple OK and Mr. Mukite and Musangi be heard first, because there is no way we can allow them to present conservatory orders argument when they are not supposed to be in this matter?
Argument not supposed to be in this matter. Parties entitled to representation
We
of
will-
his choice. That is a constitutional imperative.
Can you take your seat? Take your seat. Lepaka.
Lepaka.
Lepaka, sorry, I'm going to Lepaka. Lepaka. Do not, what do they say? Do not put the card before?
Yes.
Apply first. File your application within 7 days and we shall be talking.
Thank you.
Yes,
By the close of the day tomorrow, my lord, it will have been filed.
we want to do it instant. We have no problem. Okay, let me now read the ruling.